What happens when an attorney tells you, hey, will you take $2,000 on this case because, we all got to take a haircut here. And you say, well, I want to work with you, Mr. Attorney. We have a nice relationship. I think we have a nice relationship, but you're asking me to make a business decision. I make business decisions based on data. I need to know, who are the other medical providers? Are you taking a cut? Are you asking all the other providers to take a cut? Or are you just asking me? And so when the attorney says, well, I can't share that disbursement sheet with you because that's attorney-client privilege. They are trying to screw you, and apparently you do not have a relationship with this particular attorney because they're violating their own bar rules. So I'm going to share with you American Bar Rule 1.15. Now, this is an American bar rule. Your state bar may have something similar. It may not be American Bar Rule 1.15. But what American Bar Rule 1.15 says, it has to deal with the safekeeping of property. So if it's not Bar Rule 1.15 in your state, you can search safekeeping of property. But this is what it says. It says a lawyer shall hold property of clients or third persons. You're a third person. Your property is your bill and your notes. Your notes and your bill got the settlement that the attorney used. Your attorney used all your notes and all your and all your bill to get that settlement offer. So why are they only going to pay you some of it and not be transparent with you? So, funds shall be kept in a separate account maintained in the state where the lawyer's office is situated or elsewhere with a consent of the client or third person. It just says they have to keep it in a separate account. A lawyer may deposit the lawyer's own funds in a client trust account for the sole purpose of paying bank service charges on that account, blah, 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 blah. You don't need to know all that. This is what you need to hear. And this is American Bar Rule 1.15. Here I'm in Georgia, in the state of Georgia. It's Georgia Bar Rule 1.15, but it deals with the safekeeping of property. This is the one bar rule you need to know because this is what it says. Upon receiving funds or other property, funds to pay your bill, in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. This is the bar rule saying this. They have to call you and notify you, except as stated in this rule or otherwise permitted by law or by agreement with the client. Your patient should have signed an assignment of benefits that locks all this up. Your interest is their bill. A lawyer shall promptly deliver to a client or third person any funds or other property that the client or third person is entitled to receive, and this is the important part, upon request by the client or third person, shall promptly render a full accounting regarding such property. They have to tell you and give you a full accounting of everyone's interest in the case. The state bar, well, the American Bar Rule says it, but your state bar has language of safekeeping of property that says just that. They have to render a full accounting regarding such property. That's it. Okay? So you're going to challenge that attorney. The relationship is over. He's already trying to play games, right? You say, well, according to Bar Rule 1.15, you have to give me a full accounting. And if you don't give me that full accounting, you're going to force me to do a couple of things. The first one is, now by the way, the relationship is over at this point. So when you do this, don't expect any more clients. Okay, but why do you want to work with an attorney that wants to cut your bill and not be transparent with you? So what you're going to say is, well, Mr. Attorney, I believe you have to give me a full accounting. It's in your bar ethics rules. So what I'm going to do as soon as we hang up is I am going to file a bar complaint against you and every partner of the firm that you're in violation of Bar Rule 1.15 in our state. And secondly, I'm considering filing charges of theft by conversion. Oh! Let me read what theft by conversion is. If you send this in an email or a communication, they're going to call you back within 10 minutes. A person commits the crime of theft by conversion when having lawfully obtained funds or other property of another, including but not limited to leased or rented property under an agreement or other known legal obligation. You have an assignment of benefits, so they already know you have an interest in the case. The known legal obligation to make a specified application of such funds or a specific disposition of such property. He knowingly converts the funds or property to his own use in violation of the agreement or legal obligation. By the way, the lawyer may say, well, that's just a breach of contract. That's not theft by conversion. Oh no, it's definitely a breach of contract, but also theft by conversion. We're gonna let a judge handle it. And if it's over $20,000, that's a felony. But even if it's over $500, it's a misdemeanor punishable up to 1 year in jail. Okay. Now, we've written letters to attorneys threatening the bar complaint when they're not giving a full accounting in violation of the Bar Rule 1.15. That's the first thing. Secondly, if I don't have a check on my desk couriered by 5 p.m. on Friday, March, blah, 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 I'm considering filing charges of theft by conversion. Not only of the attorney, but also the patient, right? Send the patient that. Like, you can also do this when the attorney knowingly mails the patient the check, which they know that they shouldn't do that. It should be in your assignment of benefits that they shouldn't do that. But yeah, that's how you handle that objection. When you know their bar rules and they're violating their own bar rules, they usually snap to. Yeah, and by the way, doctors think, well, these attorneys talk to each other. They know that I file bar complaints. Yeah, they may talk to each other. They talk to other losers that are just like them. Other lawyers that are losers that try to pull these same tactics. Let them tell them all, because you don't want to work with those guys. There are plenty of attorneys in your city, in your state, that would love to work with you. So no Bar Rule 1.15, safekeeping of records, and when you get this objection from personal injury attorneys, use it, because you need to get paid, right? These attorneys push paper. You're pushing spines. It's your blood, sweat, and tears in that bill, right? Their bill is just, without your notes in your bill, they don't have a settlement offer. If you want to learn more, hit the like button, hit subscribe. Thank you so much for watching this video. Watch some other videos about personal injury marketing. And if you want to reach out, in the description, you can book a 15-minute call with me or a 45-minute Zoom call, and I'll show you the whole program. But like and subscribe. I hope I talk to you soon. Have a great day.